And welcome back. It is the first Sunday of the month, and that means Utica Attorney Mark Wolber in to answer your legal questions. If you do have any, 793-WKTV, that's 793-9588, and happy March to you.
Well, thank you. It's nice to be in March.
3 weeks away from spring.
Yes.
Looking forward to it. And we have Joseph on the line for Mark. Hello, Joseph. What's your question today?
Yes, good morning, gentlemen.
Good morning.
Say, my question has to do with taxes and student loans. I'm a disabled veteran, and I've been trying to get my student loans reduced or forgiven. I kept sending a paper into the student loan, and it says that my appointments for my physicals is deferred. Every time I'm up for a physical, it gets deferred. Would that mean that I could get my student loans reduced? Thank you.
Yes. Generally speaking, it's very difficult to reduce student loans. They are not dischargeable in bankruptcy for the most part. There's an exception here there, but generally you can't. However, there is a program that if the person who has the student loan is disabled, and you have to be able to establish a disability, then you can apply to have that student loan forgiven completely. Not just reduced, but forgiven. So the student loan will be completely forgiven. I had some information on that in my office at one point. I don't know if I have it anymore, because I did work with someone, and it does work, but it's a separate program you have to apply for. You might be able to get something online, but look for student loans discharge for disability or forgiveness for disability, and it's a separate program, but yes, you can get them discharged if you have a disability.
And does it matter when the disability happened? Obviously, it has to happen after you take out the loans.
I don't know. I don't know if there's any rule on that, but if you're disabled when the loan is due, then you're eligible for discharge. Now, if it pre-existed, if you were disabled when you got the loan, I don't know if that would matter or not. I'm not sure.
Hello, John. What's your question for Mark this morning?
Yes, good morning. I have a friend left me some things in his will when he died, but he knew me by a nickname, so I have no ID in the name in the will. How can that be corrected?
Is he already deceased?
Yes.
He's deceased, okay. The only way I would know that you could correct that is to complete an affidavit stating that you are also known as, so be AKA, also known as, so put your name down, that have also been known as whatever the name is that's in the will for many years, or for 10 years or whatever, and have that affidavit. If you can get some other people who could sign an affidavit as well, that's a name that you were known by, that might be helpful to you. So you could submit all that evidence to the executor of the will, so that the executor knows that you're that person, and then that documentation can be submitted to the court. It does bring up an issue that's very, very important. When you are doing a will, be sure that you use the person's legal name. Sometimes people will say, I'm leaving it to Skip Jones. Well, that may not be the person's real name. So you do want to make sure when you write the will, it's a formal legal document. You want to make sure you use the person's legal name. But that's the best thing that I can suggest to you, and it probably will be effective and will work for you.
Hello, Eloise. What's your question for Mark this morning?
Hi, yes, good morning.
Good morning.
I have a question regarding school buses and the legality. Suppose you're driving north on Route 12. It's a 4-lane highway with a divided barrier in the center. You're driving north. A school bus is stopped, driving south, with the red lights flashing and the side stop things are out. Now, do I have to stop in the north lane or no?
That's a tricky question. I think if there is a barrier that you don't have to stop, but that's a little bit tricky. It's probably best to err on the side of caution and stop, because they are very, very strict about that rule. And I think it's 5 points if you pass a school bus. So be very careful with that. But as far as that barrier goes, I do believe that that's an exception if there's a solid barrier that you don't have to stop, but I would probably still stop anyway.
Hello, caller. What's your question for Mark this morning? Hi, good morning.
Good morning.
Pete, I think we have on the line. Hello, Pete.
Yes, good morning.
Good morning.
I own my home and my girlfriend lives with me. At the time of my death, the house goes to my daughter. Do I need a document or does it have to be in my will that my girlfriend can stay here for a period of time until she finds a place to live?
Yes, if the home is in your name alone, upon your death, that home would belong to your estate. So if you have a will, the executor of the will would handle the estate. If you don't have a will, the administrator would. The administrator is generally going to be your nearest relative who's an adult, and that person, upon becoming the executor or administrator, would have the absolute right to give your girlfriend living there a notice that she has to leave within a certain time period, depending upon how long she's been there. And if you want to ensure that she gets to stay there for some period of time, you can put that in your will, and that is binding. So, but it's very difficult to say until she finds a place. What you're going to want to do is say that I give her the right to reside for 6 months or for 1 year after my death. And that way there's a finite period of time. But these wills that say until she finds a place, because they're so ambiguous, it can be difficult to know when that period actually expires. So you want to put in your will that I give to my girlfriend, make sure you put her full and correct name in the will, the right to reside in the premises for until, say, 1 year after my death. You do then have to put something in your will about the provisions for taxes and utilities. If you want your estate to pay for those, then that needs to be in your will. If you expect your girlfriend to pay for those, then that should be in the will that she can stay there as long as she pays the utilities or whoever's going to pay the taxes. So you want to make provisions not only for her right to live there, but who's going to pay for the charges while she's living there. And that's very important to cover that. Otherwise, that creates significant problems.
That's for sure.
That sure does.
Great questions this half hour.
Yes.
Hopefully we'll get some similar ones next
We'll
half
try.
hour. Stick around
Okay.
for us.
Thank you.
And stick around as well. Up next, sports.